Hello students, today let us learn about insurance claims, that is Insurance Act 1938 claim settlement. Objective of this lesson is to educate the students on meaning and nature of the claims payment in the insurance business, procedure of filing claims and claim payments, role of surveyors and loss assessors in the claims payment, appointment of surveyors and loss assessors, appointment of third-party administrators. Claim is the right of the insured to receive the amount secured under the insurance contract. The payment of premium is one set of the promise, whereas the promise to indemnify the insured is another set of promise. Each one of them is a reciprocal promise and a consideration for one another. Claim is a promise of the insurer to pay the compensation to the insured on happening of some uncertain event resulting in loss or damage to the asset insured. It is a pecuniary interest in the insurance contract. The amount is payable to the beneficiary on happening of the event. The event may be the maturity of the policy or happening of a risk, whichever is earlier. The payment of claim on the date of maturity, even without suffering loss, is confined to the life insurance policies and annuities, whereas in the general insurance contract, the payment of insurance arises only on happening of the event or the risk insured. Other words, the claim is payable on maturity of the policy or on the death of the insured in case of the life insurance business, and in case of the general insurance business on happening of event such as fire, marine perils, or otherwise discussed in the policy document, whichever is earlier. The Insurance Act 1938 does not clearly lay down the procedure for the payment of claims. Mostly, the claims are settled or paid according to the customs and practices recorded in the insurance manuals. The payment of claims and assessment of the loss depends upon various factors and differs from class of insurance to insurance. Claims in life insurance business differ from that of the claims in general insurance. The claim can be paid only on the written request of the policyholder or the beneficiary of the policy. The knowledge of the loss or happening of the event resulting in damage of the asset to the insurer does not relieve the insured from filing a claim. Payment of claim is an obligation of the insurer under the insurance contract. The claims management is an expert system which notifies the rules and regulations for assessment of damages using the key information contained in medical reports, surveyors reports, loss assessor reports, claims petition, and evaluation of the procedures, conditions, and warranties stated in the insurance policy. An appraisal of a claim is an evaluation or an attempt to evaluate the value of the assets lost. The claims managers, actuaries, and underwriters form the claims management group. Let us look at the insurance claimants. A claimant is one who becomes the beneficiary of the insurance policy. The primary right to claim the insurance amount is with the insured, and after the death of the insured, his legal heirs. The persons interested in claims are the policyholder is the first person to claim during his lifetime, after the maturity of the policy, or on expiry of the policy, or before the expiry of the policy by surrendering the policy to the insurer. The wife and children of the insured, on whose behalf the benefit of the policy is created. After death of the insured, the nominees appointed as per section 39 of the Insurance Act 1938. If the nominee is the minor, his or her natural guardian or legal guardian appointed by the court. Third party under the liability insurance, more specifically in case of motor vehicle insurances. The assignee or the transferee of the policy who acquires the right as per the law. The legal heirs of the insured on the death of the insured. creditor to whom the policy has been assigned with an intention to secure the debt. Now let us understand claim payments. Based upon the subject matter, the class of the insurance business, the claims may be classified into life insurance and general insurance claims. Depending upon the interests of the parties, the insurance claims may be classified into first party claims, third party claims, group insurance claims. The claims portfolio contains the claims procedures, claims settlement, policies of the insurance company, strategic and cost planning, servicing of the policies. When the claims are filed by the insurer has the option either to pay the claim if it is according to the terms of the contract, or reject the claim if it is not according to the terms. Sometimes the insurance company may negotiate with the claimant for a compromise. The important factor that influence the payment of claims are: the claimant should have an insurable interest on the subject matter which is lost and for which a claim is made. The policy should be in force on the date of event. The risk and the cause of event should be covered by the policy. The cause of loss or the event should be directly related to the loss. There should be loss or damage to the subject insured. Sufficient documentary evidence of loss should be presented along with application of claims. Disclosures or declarations should be related to the subject matter, and a contract of insurance should be true to the knowledge. The claim should not be made with an intention to make profits. The fraudulent claims with the fraudulent intention should not be made as they are against the principles of good faith. Multiple claims and reciprocal claims will be settled as per the terms of the contract of insurance. The insurance should cooperate and help the insurance company in the settlement of the claims filed by them. Every insurance claim will be considered on case-to-case basis and on merits. Let us look at claim procedure. The insured is under obligation to give a notice of happening of event immediately to the insurer. The notice, if required under the terms of the contract, should be given in writing. If there is no possibility of giving a notice immediately, should inform to the insured by the possible means. Timely and prompt notice is essential. Delay in communication may be based upon the terms and facts of the case may be lead to the rejection of the claim. The claimant cannot presume that insurance may get information about happening of event by his own resources. The notice should have the details of the event happened, such as the date and time, estimated loss, expected cause of incident, policy number, subject matter insured, and face value of the policy. In case of death of insured, information has to be given within 7 days from the date of death. The insurance company, after receiving the information, shall send the claim form to the insured. The insured or the beneficiary shall fill the information and enclose the insurance policy duly discharged along with the form. He shall submit the claim to concerned insurance office situated at a place mentioned in the policy document. After the maturity of the policy or on the death of the insured or on happening of event, the claimant should submit other documents in proof of death of the persons and to show the right of the claimant to the insurance amount. The claimant should also submit information beyond the doubt in relation to the age of the claimant and his relation with the insured and the title of the claimant and his identity. The insurance company, after receiving the claim application, should acknowledge the receipt, number the claim, and verify the preliminary information such as currency of the policy, comparing the risk or the cause of the loss with the information provided to the claimant. The insurance company may make preliminary investigation on the event and loss suffered either through its employees or by appointing licensed surveyors and loss assessors or the third party administrators. The surveyors or loss assessors are to be appointed either by the insurer or the insured immediately within 72 hours of happening of event. After receiving the report from the loss assessors and considering the evidence submitted, the insurance company shall make a decision either to pay or reject the claim. If the insurer takes a decision to honor the claim after verifying the identity of the claimants or the beneficiaries, the claim will be paid by check or transfer into the accounts of the claimants. If the insurer decides to reject the claim, should make double sure and communicate the decision of rejection by giving reasons for the rejection. The claimant or the beneficiary may appeal to the appropriate authorities for settlement of his grievance. In case of dispute or any point of claim, either about the title of the claim, identity of the claimants, the insurer may pay the amount into the court and request the court to settle the claim. Section 47 of the Insurance Act 1938 laid down the procedure that the principal officer of the insurance company should apply to the court for the permission for the payment of insurance amount of which a claim is in dispute within a period of 6 months from the date of the death of the insured. The court, after examining the facts placed before it and after satisfying, accords permission for payment of the insurance amount into the court. The payment of insurance amount as per the orders of the court amounts to be final discharge of the insurance contract, and insurer is discharged from the liability of insurance contract. The court, after receiving the amount and information, serve the notices on the claimants or nominees or beneficiary to submit required documentary proof required to support their claim. On satisfaction, the court declares certain person as a rightful claimant and insurance amount is paid to him. The authority may seek report on loss assessment and surveying on its own from an independent surveyors and loss assessors by specifying the time limits on event loss or claim of any insurance company. Appointment of insurance surveyors and loss assessors. The surveyors and loss assessors and third party administrators are the insurance intermediaries as defined in section 42D of the Insurance Act 1938. These intermediaries are associated with the claim settlements and payments. No insurer shall pay or settle the claim received from the policyholders in case of general insurance business without considering the reports of the loss assessors and surveyors. The insurer or insured may appoint the surveyors or loss assessors having the valid license. The appointment of the surveyor and loss assessor is necessary in case of motor insurance if the claim is above rupees 50,000 and in other general insurance business if the claim is above rupees 1 lakh. The appointment of the surveyor or loss assessor should be completed within 72 hours from the occurrence of loss or known to the insurer or insured. Section 64 UM of the Insurance Act 1938 duly amended in 2015 and IRDAI Insurance Surveyors and Loss Assessors Regulations 2015 laid down procedures for licensing the insurance surveyors and assessors who play an important role in claims payment. The appointment of the surveyors and loss assessor is applicable for the general insurance business. Categorization of surveyors and loss assessors. The IRDA regulations 2015 provides for different class of surveyors and loss assessors. Student member is a student having all the required qualifications and fit and proper for granting license to undertake the work of loss assessment and Surveying and enrolled with IRDAI for practical training required for a grant of license. Licentiate member. Licentiate member is a surveyor and the loss assessor having the license to practice and completed 100 hours of training and attended a minimum of 5 seminars or workshops in the relevant area. Associate member. Associate member is a surveyor or the loss assessor having a minimum of 8 years of experience as a licentiate member. The associate member should have a minimum of 50 hours of training and should have participated in a minimum of 8 seminars or workshops. Fellow members. The fellow member is a surveyor or the loss assessor having a valid license as associate member for a period not less than 16 years and had 25 hours of training and attended a minimum of 10 seminars or workshops in the relevant areas. Corporate surveyor. Any company or LLP or a partnership firm having applied and issued a valid license to undertake the business of surveying and loss assessment. All the members or partners of the firm or the company should have the valid license during the continuance of business. Without having the license, the member or partner is not permitted to undertake the business of surveying or loss assessment. Let us look at licensing or registration of surveyors or loss assessors. No insurance company or the insured shall appoint or utilize the surveys of surveyors and loss assessors unless they have the valid license to undertake the business of surveyor and loss assessor. Any individual who is considered as fit and proper for the position of surveyor or loss assessor having the required professional qualifications specified by the IRDAI and training may apply to the authority in appropriate application form along with the fee of rupees 1000 and applicable taxes. If the authority decides to reject the application, it should be doubly sure about the reasons quoted for the rejection. The application may be rejected for the reasons that it does not conform to the provisions of the Act and regulations or grant of license is not in the interest of the policyholders. The license granted is valid for a period of 3 years and same may be renewed by filing an application online or physical application along with the application fee. The renewal application has to be filed 1 month before the expiry of the license. Important duties and functions of surveyors and loss assessors. The duties and functions of the surveyors and loss assessors include the conducting inspection and reinspection of the property in question suffering a loss, examining, inquiring, investigating, verifying and checking upon the causes and circumstances of the loss in question, including extent of loss, nature of ownership and insurance interest. Conducting spot and final surveys as and when necessary and comment upon franchise, excess or under insurance and any other related matter. Estimating, measuring and determining the quantum and description of the subject under the loss. Advising the insurer and insured about the loss minimization, loss control, security and safety measures, whether appropriate to avoid further losses. Surveying and assessing loss on behalf of the insured or insurer. Assessing liability under the contract of insurance. Recommending applicability of the depreciation and the percentage and the quantum of depreciation. Commenting on salvage and its disposal wherever necessary. Maintaining confidentiality and neutrality without jeopardizing the liability of the insurer and the claim of the insured. The surveyor and the loss assessor has to submit the report within 30 days of his appointment. The surveyor and the loss assessor should adhere to the code of conduct laid down in the regulations. Some of the important provisions of the code of conduct laid down in the regulations include: behave ethically and with integrity in the professional pursuits, strive for objectivity in the professional and business judgments, act impartially and with courtesy and give equal consideration to all, not to work without license, have the knowledge of latest developments in the field, maintain proper record for work done in accordance with the laws, not to disclose any information pertaining to a client or employer or policyholder acquired in the course of its professional work to any third party except where the consent has been obtained from the interested party or where there is a legal right or duty enjoined upon him to disclose. Use the confidential information received from a client or the insurance company for the personal benefit or against the interests of the parties from the information received. Termination. The services of surveyors and loss assessors may be terminated by mutual consent of the parties, the insurer and the surveyor. The authority on finding the services of the surveyors to be detrimental or against the code of conduct or against the public policy or otherwise can cancel or suspend the license and terminate the service after giving ample opportunity for hearing. Every surveyor and loss assessor shall furnish the information, records and reports to the authority whenever asked for. Surveyor and Loss Assessors Committee. The authority may constitute a Surveyor and Loss Assessors Committee for the purpose of assisting the authority in formulating the syllabus for conducting the examinations or practical training and assessing the foreign qualifications of the candidates to find the Indian equivalences. This committee also helps in prosecuting the professionals for their misconduct of the surveyors and loss assessors. The committee is constituted with one officer of the authority, two representatives of the licensed surveyors and loss assessors, one representative of the insurers from public sector, and one representative from private sector insurers, and one representative of the policy holders. Let us look at third party administrators, that is TPA. Third party administrators are one of the intermediaries referred in section 45D of the Insurance Act 1938. Third party administrators are appointed for helping the insurance companies in settling the claims relating to health insurance business. Section 2, subsection 6C of the Insurance Act 1938 defines the health insurance business as the means, the effecting of contracts which provide for sickness benefits or medical, surgical or hospital expenses benefits, whether inpatient or outpatient, travel cover and personal accident cover. Thus, the TPAs are engaged exclusively for health insurance business and cannot undertake any other insurance business. Third party administrator is a company registered with the IRDA engaged by the insurance company for providing health insurance services for the payment of fee or remuneration. The services provided by the third party administrators as stated in Regulation 3 of the IRDAI Third Party Administration Health Insurance Regulations 2016 include servicing of claims under health insurance policies under cashless treatment or settlement of claims other than cashless treatment or both as per terms of the policy. Servicing of claims of hospitalization, cover under personal accident policies or domestic travel policies. Facilitating carrying out of pre-insurance medical examination in connection with underwriting the health insurance policies. In case of the life insurance policies, health insurance policies issued by the Indian insurers covering the medical treatment or hospitalization outside India. Servicing the foreign travelers in India for the policies issued by the foreign insurers, the TPA cannot issue the health policies directly or solicit the insurance business on its name directly or indirectly. Appointment of third-party administrators. A company having interests to undertake the TPA services may apply to the IRDAI in prescribed form. The company should have the words Insurance TPA as part of its name. The company should have a minimum capital of rupees 4 crores and additional 1 crore rupees towards the working capital. The company should have at least one director with MBBS qualification. All other directors should possess a degree issued by the recognized university. The CEO, CMO, CAO should be a fit and proper person having all the qualifications stated in section 42D of the Insurance Act 1938 and should not be disqualified. The TPA should have networking agreements with the hospital. TPA can serve more than one insurer, and insurer may also appoint more than one TPA to facilitate its health insurance business. The authority, after verification and satisfaction, may issue a certificate of registration and permit the TPA to provide the services. The TPA should pay rupees 30,000 after receiving the communication of accepting the application for issuing the registration certificate of TPA. The TPA should commence its business within 12 months of the issuing the certificate of registration. The registration certificate is valid for a period of 3 years. The TPA should apply for renewal of application before the expiry of the registration. The authority may issue a duplicate registration certificate on payment of prescribed fee fixed by the authority from time to time, either on loss or mutilation of the original certificate. The TPA, for reasons stated in its application, may surrender the registration certificate voluntarily to the authority. The authority, after verifying the application submitted by the TPA, if not satisfied, may seek further information from the TPA and may reject the same if not satisfied with the information provided by the TPA. The TPA should strictly follow the code of conduct provided by the authority in Schedule 2 of the regulations. Non-settlement or delay in settlement of claims may lead to the disputes between the insurance companies and the policyholders or the beneficiaries under the policies. The litigations may cause huge loss of money, time and reputation of the parties. As such, before rejecting the claims, the insurance companies are bound to verify their decisions of rejection of claims to avoid the prolonged litigations. Friends, today we learned about the process and procedure of filing applications for claims, the method of appointing the surveyors and loss assessors, and also role of the third party administration in settling the healthcare policies.